At-will employment covers about 90% of the workforce that we have in the United States and actually around the entire world. So we look at-will employment. Let's talk more specifically about what that means and the impact that it'll have in the regular workplace. You'll have variation from one state to the next, really from one jurisdiction to the next, sometimes different jurisdictions within the same state as to what exactly is public policy. It may be that an attorney is shopping for its own venue, saying, well, I'm going to find a jury friendly to me over here or here or here. So they may, depending upon the size of the company and the case, they may try to shop that person around saying, okay, let's go to trial here. We're going to file in this area. You will see that on a regular basis, especially from very sharp attorneys trying to find the best venue. But public policy, really, it's a matter of what was the termination about, and was the employee following a certain duty, a certain right that they had? Did they refuse to disobey a law? Were they directed by the employer, do this, even though the employee said, no, I can't because it's against the law, and they were terminated for that? Did the employee report a safety issue? Did the employee go through and report that this is an issue we should be concerned about, and boom, they're terminated? Sometimes it's inappropriate to the point that you can actually file a suit in the process. Terminations could be a response to somebody complaining about the fact they're being picked on for discrimination. Harawi versus the Alabama Department of Forensic Science. Harawi made a complaint that they're being picked on because of their Iranian heritage, and shortly thereafter, they were found by the Alabama Department of Forensic Science to sit down and not be performing their duties. The allegation by Harawi was Alabama made them uncomfortable because they complained about discrimination. Alabama said, no, that's not it. You're not doing your job. We're going to terminate you. So they terminated Harawi, and that person sued and claimed discrimination, and he won the case. Here you have a situation was what happened first. Harawi and the court found that the Alabama Department of Forensic Science, they felt that the atmosphere changed with the intention of discharging Harawi based upon heritage after there was a complaint filed. So you have that aspect of it. That's a retaliatory discharge, is what they said happened because of the fact that they filed the claim, and then shortly after, the work performance was found to be lacking. So that being said, the court found it for Harawi. Now, pay attention to what's involved in the process. Sometimes you have something happening in the workplace, okay, and the performance is exemplary or fair at least, okay, and then outside the workplace, things are happening from legally protected activities, okay, and so because the two happen, one out over here, one on the inside, does the employer then terminate the employee because of something that they said outside of the workplace? Now, usually that's the case because it's protected speech, but sometimes there are activities happening outside the workplace where they're dragging the name of the company into the public limelight in a different venue that's inappropriate, that they didn't want to be there. So there are different examples of both of them. On the free speech issue, okay, for example, you had a Google Damore firing. You have that over there, free speech. Google has run for years a loosey-goosey aspect as to having different boards posting, and so people can post almost anything except for the fact that sometimes they become overly rambunctious in the leanings to the posts that are not related to the actual work. So with that, sometimes outside activities and interests roll into the workplace inappropriately, and that happens typically almost every single place that you work. If you work there long enough, you'll see all that happening. When do you sit down and correct it? When do you try to bring the proper balance back that work is about work? Keep your personal beliefs and politics outside the workplace. Sometimes they overlap, but generally it's a matter of opinions that affect other people in the workplace that maybe sometimes didn't appreciate. Sometimes participation in a protected activity, whether it's in the workplace or outside the workplace, if it has an adverse employment action, can there be a causal connection between the two? A protected activity resulting in an adverse action is called a retaliatory discharge. Okay, I did this. I filed the discrimination complaint. Boom. All of a sudden now, You're sitting there saying, I'm not working hard enough, I produce the same as everybody else, and then they found a causal connection between the two and with an adverse reaction. A person has the right to complain about discrimination. We should all have a safe workplace. But on the employer's part, there's a covenant of good faith and fair dealing. It's going to depend as to what just cause for termination protection is all about. The court examines the parties' actions to ascertain whether the demonstration was really a matter of bad faith that took place during the termination, or was it correct action based upon performance. You'll see a lot of different examples there. There's Gus versus Bechtel National. You have that. A lot of different states will recognize exceptions on it, and we'll talk about those different situations in a little bit in a different section. There is an implied contract when you have an employee handbook, especially about the language that's used. Make certain that an employee handbook actually is current and up to date, number one. A lot of times, soon as you publish a employee handbook on paper, it's really got changes the next day. So you're better off having an online employee handbook that can't be hacked, so some could change the language in it, but make certain the employee handbook is drafted with care. Too often, the person in charge of employment law in an organization, they will delegate the creation of the employee handbook down to lower levels within the echelon, and they create that, and it's published out there without good process review, and something is said like permanent versus full-time employee. I've seen that error. I've seen that error, warn somebody, and a year and a half later they had a lawsuit because he didn't feel like changing it or for whatever reason, and they were sued as to what the word permanent means. Okay, a permanent employee is not a permanent employee. There's no such thing as a permanent employee because they're a full-time employee, and what does permanent mean? It can mean from birth to grave, possibly. It just depends how that employee wants to interpret permanent, or the court, whether it be the judge or the jury. Specific terminology. Make certain that you maintain files in one location. There is only one place employment files are kept. They are not kept in a supervisor's desk. They're not in the employee's desk. They're not involved into an executive assistant's desk. It's human resources. There is one permanent file. It should be in a fireproof cabinet or locked away electronically, making certain there is one file and that's it. So don't have different files and pretend that they actually are relevant. There's one relevant file for every organization. It should be in one location, and every single transaction between the employer and the employee, whether it's a regular pay change, whether or not it's a classification change, whether it's a record of good performance, whether it's an evaluation, whether it's a negative memo going into their file, one file folder, and that way you can track all the different language and determine whether or not you have an implied contract or not. Now, you also have a promissory estoppel, and that happens when you sit down, the employer makes a promise, and the employee actually acts upon what was promised because they relied upon the word of the supervisor or something that was out there put out in a memo, and all of a sudden the employer reacts because of the fact it's not what they meant in their own mind. Now, that being said, you may have a tort file because it's an implied contract claim. So whether it's implied or expressed, okay, whether they meant that or not, it doesn't contradict a contractual term. So that's where you'd have that proven in different venues. Here are some statutory exceptions to employment at will. OSHA, sometimes some work is not safe. Okay, the Fair Labor Standards Act in regards to fair pay, Pregnancy Discrimination Act about somebody that is pregnant. Sometimes you have a constructive discharge, and that occurs when the employer creates an intolerable workplace condition. I was treated this way, and I was doing fine in my job. I complained about this, and all of a sudden I had doubled the work. I had doubled the work here, and here's a quantification of my work versus the person next to me, and we hold exactly the same job. I was fine before, now all of a sudden my workload was over here. People were invited to go to different conferences. I wasn't. I was left back in my office. So I just quit. Well, you created an environment deliberately. If what they're saying is true, it was a deliberate creation of intolerable conditions in the process. So that justified a resignation. And the employee may well go the next step and file an example in court as to all the different things that happened and then sue. And you have the situation of an Egyptian-born doctor subjected to extreme pattern of discrimination, okay, and they were forced out by being pushed in this process over here, saying, oh yeah, I had to leave because they kept on picking me because I was Egyptian-born. Different factors could justify resignation, and if they can prove it in a court of law, which is extremely difficult, okay, it's a heavy burden of proof, but if they do, it looks like you've been intentionally targeting, then a lot of times a jury will find on their behalf. A lot of other restrictions on it. There's different aspects of it. You'll see different levels where laws are out there for different levels of employees. Typically, the threshold is 60 employees for federal law, but you'll see different versions by the time it's all done. So business changes, whatever happens, sometimes firms can actually give people short-term notices citing lost productivity, sabotage, or theft. It could be if you have a fire. There's different ways that all of a sudden the at-will doctrine, you might have to sit down there and actually close up a division, section, or just reduce the overall workforce. At-will employment basics. Whistleblowing, employees who report wrongdoing. Avoid sloppy language. Permanent versus full-time is a good example. Cautions on publicly protected acts. Somebody has a right to picket to represent their own causes outside of the employment venue. They have a right to do that, and you don't have a right to terminate them for most of those situations. Constructive discharge, creating a world where people sit down and have a miserable life because of the fact that you felt they did something inappropriate. Okay, and then keep in mind that 2/3 of employee lawsuits on the employer are based on how they were released. It's a big deal. At-will employment basics, it's a big part because there's so many people that live in this category. Take care.